Okay, picture this. You're running a factory. Workers are on edge, and someone whispers strike.
And in the background, this entire code is quietly deciding what everyone can and cannot do.
Today we're doing a visual recap of the Industrial Relations Code 2020.
Yeah, the big one that rolled trade unions, standing orders and disputes into a single framework.
So we'll tell you what this code is, then zoom into 3 big themes, then tie it all back.
Those 3, trade unions and negotiation, standing orders and discipline and disputes, strikes, layoffs.
And if you're watching, we'll keep pointing to the slides so you can follow along.
Let's pull up the very first slide, page 7.
Here it is, 7, short title, extent and commencement, classic opening shot.
It says, "This may be called the Industrial Relations Code. It extends to all of India."
And the kicker, commencement is staggered, different dates for different provisions.
Which is why on page 7 you see a note, the actual start date notification in 2025.
So this isn't ancient history. This is live law impacting factories, IT parks, ports, everything.
Right, because if you look at 7, appropriate government includes central control over railways, mines, ports.
Okay, hook question. Why should a regular worker or HR manager care about this huge code?
Slide 66 answers that. The object is industrial peace and harmony, with real tools.
Industrial peace sounds like yoga for factories.
In a way, yes, it's about reducing surprises, giving predictable rules on disputes, layoffs, strikes.
All right, theme 1. How people organize and bargain, trade unions and negotiation.
Pull up the content slide for trade unions, page 53.
Nice index. From Registrar of Trade Unions, Section 5, down to recognition at central and state level, Section 27.
The story here is who can form a union, how it's registered, and who speaks for workers.
Let's start at the top, the Registrar, page 65.
Section 5 says, the state government appoints a registrar and other officers to handle registrations.
So every union's life kind of begins in this office, with a very overworked registrar.
For sure, and they decide whether you even qualify as a trade union under this code.
Jump to page 65, Criteria for Registration, Section 6.
2 key thresholds, at least 7 members to apply, and
at least 10% or 100 workers, whichever is less, must be members.
Correct. That 10% rule tries to avoid fly-by-night unions with 3 friends and a banner.
There's also a safety valve, page 65. You don't kill the application if a few applicants drop out.
Yes, Section 6, subsection 3. Even if up to half of the original applicants leave, application survives.
It's pretty realistic. People get scared, transferred, pressured.
Exactly. The law anticipates churn and still protects the collective effort.
Okay, once you clear the numbers, you need a proper constitution, page 16 and 16.
Section 7 lists mandatory rules, name, objects, how general funds will be used.
And on 16 and 16, you see the nitty-gritty audits, AGM, election of office bearers every 3 years.
That 3-year election cycle is meant to keep leadership accountable and not fossilized.
Unless the union quietly ignores it, which happens.
True, but remember, Section 26 on 22 lets the registrar inspect accounts and records.
So there is some external pressure to behave.
And Section 26 also requires annual audited statements to be filed. That's transparency in theory.
Speaking of structure, I love page 18, Incorporation of a Registered Trade Union.
Section 12, once registered, the union becomes a body corporate, can own property, sue and be sued.
So it's not just a protest group, it's a legal person, like a mini company with a stamp.
Exactly, accompanied by Section 13 on 18, other acts like the Societies Registration Act won't apply.
Now, what about who can join? Page 20 is interesting.
Section 20 says, anyone 14 and above in non-hazardous industry can be a member.
14, that's school age, but it reflects real child labor realities, sadly.
Yes, and the code at least lets such young workers organize, which can be protective.
Leadership limits are on 20 and 20. You must be over 18, and no recent conviction of moral turpitude.
And the tribunal can disqualify an office bearer, under Section 21, page 20.
Plus, Section 23 on 21 caps outsiders in leadership. Most office bearers must be from the industry.
Right, except in unorganized sector, where at least half must be actually employed in that sector.
So the law is trying to avoid unions run entirely by professional politicians.
Hence, Section 22, page 21, ministers and people with offices of profit can't be union office bearers.
Do you like that rule, or do you think it weakens political leverage?
Mixed. It reduces capture, but also cuts off some powerful allies. Depends on your view of politics.
I kind of feel workers sometimes need those big guns, but yeah, capture is real.
The code tries to balance that by giving unions some legal shields.
Immunity time? Page 20 and 20.
Section 16. Unions get civil immunity for acts done in contemplation or furtherance of an industrial dispute.
So if a union calls for a peaceful boycott and a supplier loses business, they can't simply sue.
Correct, as long as it's about an industrial dispute and not beyond the code.
And Section 17 on 20 softens criminal conspiracy rules for union activity.
Yes, agreements to further lawful union objects won't be treated as criminal conspiracy.
There's also protection for internal agreements. Page 20.
Section 18. Union agreements aren't void just because they restrain trade, like deciding members won't take overtime.
So inside the union, people can commit to some pretty strong collective strategies.
As long as enforcement doesn't go into torts like violence or intimidation, which are separately penalized.
We'll come back to unfair labor practices, page 63. That's juicy.
Before that, a big practical question. Who actually gets to negotiate?
Exactly. We've all seen multiple unions fighting, not against management, but against each other.
The code's answer is in Section 14, pages 19 and 19 and 19.
Slide 19. If there's only one registered union, the employer must recognize it as sole negotiating union.
If there are many, page 19 says, the union with 51% or more support becomes sole negotiating union.
And if nobody crosses 51%, page 19, you get a negotiating council.
Yes, any union with at least 20% support gets a seat, one rep for each 20% chunk.
So a place with 3 medium unions will have them all at the table.
Ideally, yes, representation mirrors actual support on the muster roll.
And 67 actually lists this idea as a key feature. The negotiating union, negotiating council mechanism.
Section 14, subsection 7 on 19 also says the establishment must provide facilities to these bodies.
Facilities can mean room, notice boards, maybe leave for meetings, that stuff.
Exactly. The details are left to rules, but the principle is recognition and access.
Big picture. This first theme is about turning worker anger into structured voice through unions and councils.
And giving employers a single or limited set of negotiating counterparties instead of chaos.
Okay, second theme. The rulebook inside the factory, standing orders, and discipline.
Pull up the chapter $4 contents, page 54.
Here, sections 28 to 39, from application to model standing orders to discipline timelines.
Think of standing orders as the workplace constitution, daily rules everyone must live by.
Page 23, section 28, tells us where this chapter applies, 300 or more workers.
Yes, any industrial establishment with 300 or more workers in the past year must have certified standing orders.
And government can notify some services where this chapter won't apply, like certain civil service rules.
On page 23, section 29, the central government drafts model standing orders.
So the center publishes a template, like a standard employment rulebook.
And until your specific standing orders are certified, those model orders apply by default.
That's powerful. You can't just linger in a vacuum with no written rules.
Then, section 30, page 23, tells employers to prepare draft standing orders within 6 months.
And crucially, on 38, they have to consult the trade union or negotiating union or council first.
Right. It's not supposed to be a unilateral HR wish list.
But if an employer simply adopts the central model as is, Section 30, subsection 3 says it's deemed certified.
Yes, but the certifying officer can still direct amendments. See proviso on 38 and 56.
Once the draft goes in, the certifying officer circulates it, calls comments, holds hearings.
Section 30, subsections 5 to 8 on 24, and 24 show that whole mini trial.
And if the officer doesn't act within 60 days, 24 says the standing orders are deemed certified.
Deadlines again. The code really doesn't like endless limbo.
You also see on 25 that a group of similar employers can submit joint standing orders.
Which is clever. It standardizes rules across, say, a cluster of small factories.
Okay, once certified, when do these orders kick in? Page 25.
Section 33. They come into operation 30 days after copies are sent, or 7 days after appellate order.
And they must be displayed for workers in a language and manner prescribed.
Section 34 on 26 requires a public register of standing orders, making them accessible.
So you can literally walk in, pay a fee, and get a copy. No more secret rules.
And if there's confusion about what a clause means, Section 37, page 26, lets you go to the tribunal.
That's like a Supreme Court for how your shift timing clause should be read.
Pretty much, and the tribunal's interpretation is binding on both sides.
Page 26 is another key piece, modification.
Standing orders can't be modified within 6 months, unless there's mutual agreement.
So no overnight, oh, by the way, your leave policy changed last night.
After 6 months, employer, workers, or unions can apply for modifications, and the same certification process applies.
26 literally says, treat modification like first-time certification.
And Section 36 on 26 bans oral evidence contradicting the certified orders. Only the text matters.
That's huge, no more. But sir, we always did it this other way.
Exactly. If practice diverges, they should amend the standing orders, not rely on unwritten customs.
And if an employer just ignores this whole regime, penalties show up on 49.
Failure to submit draft standing orders or unauthorized modification, minimum $50,000 fine, can go to 2 lakh.
Plus $2,000 per day for continuing offense. That adds up fast.
Acting contrary to certified standing orders, minimum 1 lakh, up to 2 lakh, and higher penalties for repeat.
So on paper, ignoring standing orders is expensive.
In practice, enforcement depends on inspectors and complaints, but the teeth are there.
The other side of this chapter is disciplinary process, page 26 and 26.
Section 38. If a worker is suspended pending inquiry, investigation, and inquiry should ordinarily finish in 90 days.
That word ordinarily makes me nervous. Loophole alert.
True, but subsection 2 forces standing orders to provide subsistence allowance.
And 26 fixes rates, 50% wages for first 90 days, then 75% if delay isn't worker's fault.
So there's direct financial pressure on employers not to drag cases endlessly.
Still, you can imagine messy cases going beyond 90 days with both sides blaming each other.
Definitely, reality is complicated, but at least the code recognizes the harm of indefinite suspension.
Theme 3, the big battlefield, disputes, strikes, layoffs, retrenchment, closures.
Let's put up the dispute resolution architecture, page 4 and 54.
Slide 4 shows chapter the 7th. Conciliation officers, industrial tribunal, national industrial tribunal, awards.
First peacekeepers are on 28, conciliation officers.
Section 43 allows government to appoint conciliation officers for areas or industries.
Their job, as 33 says, is to investigate disputes quickly and try to get an amicable settlement.
And they have civil court-like powers, as 31 shows, to summon people and inspect documents.
Yes, they can compel attendance and production of documents.
Conciliation starts on 60, page 36, from the first meeting after a strike or lockout notice.
And it concludes either with a signed settlement or with a failure report.
Section 53 on 33 and 33 ties this to notice under Section 62 and sets a 45-day reporting window.
And an even tighter 14-day window where there's a notice of strike or lockout. See 33.
So the code is basically saying, talk fast before you escalate.
If conciliation fails, disputes can go to tribunal. Section 44, page 29.
Industrial tribunal is a 2-member bench for serious stuff, 1 judicial, 1 administrative member.
In some cases can be heard by a single member, as 29 explains, depending on type of dispute.
Who qualifies as members? Page 29 and 30.
Judicial members follow Finance Act rules. Administrative members must be at least joint secretary rank or equivalent.
And 48 on 31 says members must be independent and below 65 years.
Tribunal and National Tribunal have civil court powers. Section 49 on 31 and 31.
They can summon witnesses, order document production, issue commissions.
Plus, under Section 50 on 32, they can set aside dismissals, order reinstatement, or impose lesser punishments.
And 56 on 34 says, if employer appeals a reinstatement award to High Court or Supreme Court, full wages must be paid in the meantime.
Subject to the worker not already earning elsewhere, proven by affidavit.
There's also confidentiality protection. Page 37, Section 61.
Yes, sensitive business or union information given in proceedings can be kept confidential on request.
Then, Chapter the 8th, Strikes and Lockouts, page 55 and 37.
Section 62 on 37 is central. It lays out when strikes and lockouts are prohibited.
Workers can't strike without 60 days prior notice, can't strike within 14 days of notice, or before the date specified.
And they can't strike during conciliation, and 7 days after, or during tribunal, national tribunal, or arbitration proceedings, and 60 days after.
Same mirror rules for employers declaring lockouts, 62 subsection 2 on 38 and 38.
If strike or lockout violates these, Section 63 on 38 and 38 calls them illegal.
But 38 has an interesting nuance. If a strike was legal when it began, it doesn't suddenly become illegal just because a reference is made, unless prohibited.
Yes, and a lockout in response to an illegal strike isn't counted illegal, and vice versa.
There's also a money angle. Section 64 on 38. No one can fund illegal strikes or lockouts.
Penalties are on 49. Workers joining illegal strike can face fines, 1,000 to 10,000 rupees, or up to a month in jail.
Employers for illegal lockouts, 50,000 to 1 lakh, or up to a month in jail. Section 49 again.
And instigators or funders get hit under 49, with fines up to 50,000 and possible jail.
To balance that, Section 93 on 53 protects people who refuse to join illegal strikes or lockouts.
They can't be expelled from unions or societies or deprived of benefits for that refusal.
So the code fences off industrial action pretty tightly.
Yes, it makes strikes last resort, after notice and conciliation, not spontaneous walkouts.
Do you think it overconstrains the right to strike?
It's arguable. Some say the long notice kills tactical leverage. Others say it protects the economy.
Listeners can judge, but you can see the intent reduce sudden shutdowns.
Which is exactly what the statement of objects on 66 points towards.
Now, the economic heartache chapters, IIs and X on layoffs, retrenchment, closure.
Slide 55 and 5 show their structure, sections 65 to 76, then 77 to 82 for special bigger establishments.
First concept, layoff. Definition on 10 and 10.
Layoff is when employer can't give work for reasons like shortage of power, raw material, breakdown, stock accumulation, natural calamity.
And if a worker shows up, isn't given work within 2 hours, they're deemed laid off for the day.
Unless they are told to come in second half and get work, then it's half-day layoff.
Section 65 on 39 narrows where standard layoff rules apply.
Right. Section 67 to 69 don't apply to seasonal or intermittent establishments, or those with less than 50 workers.
Continuous service is defined on 39 with all those calculations for 190, 240, 95,120 days.
Yes, it counts legal leave and non-illegal strikes, lockouts, and accidents.
Section 67 on 40. Workers with 1 year continuous service, when laid off, get 50% wages for layoff days.
Basic wage plus Durness allowance, excluding weekly holidays.
But if layoff exceeds 45 days in 12 months, compensation can stop after that if there's an agreement.
And Section 67's explanation on 40 lets employers set off previously paid layoff compensation against later retrenchment compensation.
Section 68 on 40 forces employers to maintain muster rolls so workers can mark attendance and claim layoff benefits.
Section 69 on 40 lists situations where no compensation is due, like refusing suitable alternative job nearby.
So both sides must act reasonably. Show up, accept decent alternative work.
Then we come to retrenchment. Section 70, page 41.
Conditions precedent. 1 month notice with reasons or wages in lieu.
Plus compensation of 15 days average pay per completed year of service, and notice to government.
Procedure for who gets cut is in 71, page 41.
Last in, first out, unless employer records valid reasons for retrenching someone else.
And 72 on 41 says, if you hire again within a year, you must give retrenched workers priority.
Transfers and closures also trigger compensation. See 73 on 41 and 75 on 42.
Section 73. If ownership changes, workers get retrenchment-like compensation, unless 3 conditions protect continuity.
Same or better service conditions, no interruption, and new employer recognizes continuous service for compensation.
Section 74 on 41 and 42, 60 days notice before any closure, with some exceptions.
And 75 on 42 says closure entitles workers to compensation like retrenchment, with some limits for unavoidable circumstances.
Then 76 on 43 overrides inconsistent laws, but keeps more favorable worker benefits alive.
Exactly. It's a floor, not a ceiling.
Now Chapter X. The special regime for big establishments, pages 43 and 5.
Section 77 applies where 300 or more workers on average were employed in the previous year.
And government can raise that threshold by notification. 67 explicitly mentions this design.
Yes, objective clause on 67 says 300 plus workers in mines, factories, plantations need prior government permission for layoff, retrenchment, closure.
Under Section 78, page 43 and 44, you can't lay off without prior permission, except for a few emergencies.
Shortage of power, natural calamity, and some mine-related accidents are exceptions.
But even then, mine layoffs beyond 30 days need permission, 44.
Section 78, subsection 4 on 44 lets government grant or refuse permission based on genuineness, adequacy, workers' interest.
If they don't respond in 60 days, 44 says permission is deemed granted.
And any order is binding for 1 year.
If an employer skips permission or is refused and still lays off, 44 calls the layoff illegal.
Workers then get full benefits as if they had not been laid off.
There's similar machinery for retrenchment under 79 on 4, 5, 4, 5, 4, 6.
3 months notice, prior permission, 60-day deemed approval, 1 year validity, compensation of 15 days average pay.
And for closure, Section 80 on 4, 6, 4, 6, 4, 6, 4, 7.
Employer must apply for closure permission 90 days in advance. State reasons, copy workers.
Government again has 60 days, then deemed approval, and must weigh public interest. Page 46.
On permission or deemed permission, workers get compensation similar to retrenchment. Section 80, subsection 8 on 47.
Across all this, employers' duties to maintain muster rolls repeat in Section 81, page 47.
And Section 82 spreads some Chapter the 9's protections into Chapter X setups.
Compensation, re-employment rights, and override clause 76 carry across.
If employers mess this up, Section 48 hits them, minimum $50,000, up to $2 lakh, more for repeat.
So non-compliance is meant to be painful.
Yes, especially for serial offenders.
Now, there is one very different feature here, page 47, Worker Reskilling Fund.
Section 83, government sets up a worker reskilling fund.
The fund has 2 main sources, employer contribution equal to 15 days' wages per retrenched worker, and other sources.
And subsection 3 on 47 requires that 15 days' wages be credited to the worker's account within 45 days.
That's like a tiny runway for a retrenched worker to upskill or survive.
Very small runway, yes, but symbolically it reframes retrenchment as partly a skills transition moment.
The statement of objects on 67 highlights this. Right after prior permission, they mention reskilling fund.
Right, the policy story is more employer flexibility, but also a structured cushion.
Whether 15 days actually helps is a different debate.
Very true, especially for older workers or local economies with few jobs.
Before we wrap, we should touch unfair labor practices. Page 6, 63, 63, 63, 63.
Chapter 12, Section 84 simply says, no employer, worker, or union shall commit any unfair labor practice.
The details live in the second schedule, and the snippets we have start at 63.
On 63, for workers and unions, unfair practices include supporting illegal strikes, coercing others, violence, garrows.
And 63 explains go slow, where workers deliberately reduce pace to pressure employer.
While 63 and 63 show employer side, like sacking people with undue haste, long-term casualization, refusing good faith bargaining,
and failure to implement awards or settlements, or using lockouts as a weapon.
Section 48, subsection 5 punishes any unfair labor practice, min 10,000, up to 2 lakh fine.
Repeat offenses, 48, jump to 50,000 minimum, up to 5 lakh, and possible jail.
So the code is not only about procedures, it also frames what fair play means in industrial relations.
Okay, let's do a quick lightning round. Myths versus what these slides actually say.
Go for it.
Myth 1. A small group can register a union with no real backing.
Fact. Section 6 on 65 demands at least 10% or 100 workers, whichever is less, as members.
Myth 2. Standing orders are just HR policies. They don't really matter legally.
Fact, once certified, Section 36 on 26 forbids oral evidence to contradict them. They're binding like mini-law.
Myth 3. You can announce a sudden strike tomorrow because you're angry today.
Fact, Section 62 on 37 forces 60 days notice bans strike during conciliation and tribunal proceedings.
Myth 4. Retrenchment is just firing with no cost.
Fact, Section 70 and 75, 41, 42 require notice, compensation, and often government notice or permission.
Myth 5. A retrenched worker just walks away with nothing but memories.
Fact, beyond statutory compensation, Section 83 on 47 mandates a 15-day wage reskilling credit.
Nice now. Recap time. What did we actually walk through?
First, we saw how the code structures trade unions, from registration and leadership rules to negotiating unions and councils.
Second, we saw standing orders as the internal constitution, with certification, modification, clear timelines, and disciplinary safeguards.
Third, we traced the dispute pipeline, conciliation, tribunal, awards, plus controls on strikes, layoff, retrenchment, closure, and the reskilling fund.
If you're an employer, one concrete action, go back to pages 23, 30, and 26 and check if your standing orders actually match the code.
If you're a worker or union member, look at 14 on 19 and 19 and ask, who really has negotiating status in your establishment?
And for everyone, maybe sit with 66 tonight and ask in your workplace, are we any closer to that promised industrial peace?
Because ultimately, these sections are just tools. The real peace depends on how people use them.
Philosophical Adam has entered the chat.
Occupational hazard.
All right, we'll leave the slides up for a bit. Scroll through 7, 53, 54, 55 if you want a quick visual summary.
And we'll be back with another visual dive into the next piece of labor law soon.
Till then, read your standing orders. Seriously, you'll be surprised what's in there.
And maybe what's missing.
See you next time.